Good morning to everyone. Good morning or good evening, depending or good afternoon, depending in which part of the world you are in this moment. My name is Luca Belli, and I will be the moderator of this session on the regulation of artificial intelligence and personal data in the BRICS countries. So let's start with a little round of presentations regarding this session that is organized by the Center for Technology and Society at FGV that I direct, and the CyberBRICS project of CTS-FGV that I also have the pleasure to direct. Many of the panelists today are either researchers or visiting scholars at the CyberBRICS project, and we will have the pleasure to have with us Laura Schertel Mendes, who is not a CyberBRICS team member, but a good friend, and she is professor of IDP, the Brazilian Public Law Institute, and also she is the rapporteur of the Senate Commission for a proposal for an AI framework, an AI regulatory framework in Brazil. Then we will have Ekaterina Martynova, who is researcher at the Higher School of Economics in Moscow and is one of our visiting researchers here at FGV Law School. Then proceeding in BRICS order, we will have Smriti Parsheera, who is a researcher at the Indian Institute of Technology in Delhi, and also one of our research fellows here at CyberBRICS research project. Then we will have Wang, who is researcher at the University of Hong Kong, and also one of our research fellow here at CyberBRICS. And then last, but of course not least, we will have our friend Sizwe Snail, who is professor at Nelson Mandela University. He was former board member of, former board member of the Information Regulator of South Africa, and is also one of our visiting professor here at FGV Law School. Before we start, let me set the scene with a little bit of introduction regarding why we have decided to organize this session and why it is so pressing. So as you already might know, these five large emerging economies, the BRICS countries, Brazil, Russia, India, China, and South Africa, they all adopted or renewed data protection law, or try to adopt. In the case of India, we will see with multiple iterations of the data protection bill over the past couple of years. So all of them, they have made enormous advancements in terms of data protection policies and regulation. Most of them have already enacted AI strategies. China has already implemented its algorithmic recommendation regulation, and all the others are studying with different level of maturity the idea of creating AI frameworks. So we really have enormous policy making efforts ongoing. And if we think that the BRICS countries, these five countries by themselves alone include more than 40% of the world population and more than 45% of the internet population, we understand that there is a huge impact in terms of these policy choices that the BRICS countries are making. And even more impactful will be these choices, considering that AI is really entering into our lives. We have seen over the past months with the great success of ChatGPT, how these chatbots and AI systems are already very much developed to be consumer-facing, maybe developed in not considering duly all the obligations that already exist in data protection laws determine. In the case of ChatGPT is quite telling. I have personally petitioned the Brazilian regulator to verify whether the chatbot it is in compliance with data protection law, the national data protection law, the LGPD in Brazil, because of course these systems are very frequently developed by hoovering large amounts of data online to develop large language models, and considering online personal data as an available resource, which is clearly not the case, right? The reason why data protection law exists is precisely because personal data are not an available resource, and to process them, you need to comply with existing norms, including transparency, including purpose specification, and so on. So the great tension that we find nowadays is not only the need to regulate AI in a sustainable way and as fast as possible, because it's already entering in our life, but also the need to implement existing data protection regulation. It's already there in most cases and really needs to be implemented seriously. Now, to speak about this, let's enter into the core of the debate with our speakers. I would like to give the floor first to Professor Laura Schertel. She has been directly involved in the Brazilian policymaking efforts regarding, of course, both the LGPD, but also the new proposal. So please, Laura, the floor is yours.
Thank you so much, Luca, for the invitation. I would like to thank CTS for this invitation as well, and greet all the participants of this interesting panel. So I would like to do a quick presentation. I know that we don't have so much time, but I'm going to try to share my screen, okay? Can you see it? Okay, perfect. So, okay, so as you already told us, Luca, I'm a professor at IDP Brasilia and at UNB, and I'm currently in Frankfurt as a senior researcher at the Goethe University. And I would like to talk a little bit about this process of regulating AI and of drafting a bill that just has been done in Brazil. So in this context in which there is a growing debate on regulating AI, Brazil is also dealing with this issue. And there is an ongoing agenda on AI regulation in our parliament. I would like to give an overview of this process and of the main structure of the bill that has been recently proposed by the Brazilian Senate. Several studies and international recommendations have highlighted the impacts of AI systems on individuals and society, such as their opacity, complexity, dependence on a large amount of data, and discriminatory potential. In this sense, these systems can pose a number of risks to the democratic legal order by reinforcing social inequality and discrimination, amplifying the problem of asymmetries and the concentration of power by companies, intensifying manipulation of information and the spread of disinformation, and environment damages as well. Adequate regulation is therefore an important factor to enable the development and application of safe and trustworthy AI systems in compliance with the Brazilian legal framework and constitutional freedoms. The issue is challenging in Brazil and worldwide. It is complex, horizontal, multidisciplinary, and involves unintended consequences of the use of technology in different social contexts. The Brazilian Federal Senate established a legal experts committee in February 2022 to support the regulation of artificial intelligence in the country. I was the rapporteur of this committee, which has presented a report with the draft bill at the end of the year. This draft has turned now into a bill, and the bill is number 2338 from this year. It was proposed on the beginning of May. So in Brazil, the intent to regulate AI started in the year 2019 with the proposal of 3 bills by the Congress. And as you can see, this bill 21 from 20 was approved expeditiously in 2021 by the House of Representatives. There are lots of shortcomings on this proposal. It doesn't address the negative impacts of AI, revokes existing norms, and doesn't provide for any governance structure. So that was why the Federal Senate decided to install an expert committee to discuss the issue and propose a new bill. The aim was to deepen the debates and allow a more comprehensive analysis, as well as enable more stakeholders to join a public debate. After 9 months of work, during which more than 60 experts were heard in multi-sectoral public hearings and one international seminar, the committee presented a report with a draft bill on AI regulation. The hearings brought many important inputs, such as the idea that principles alone were not sufficient to guide AI providers and operators. It has been said very strongly that there is a need of more concrete norms. The concept of AI should cover not only machine learning, but also approaches using logic and knowledge representation, since one has to look on the impacts of these systems. A centralized governance structure is necessary to guarantee the rights of those affected in a harmonized manner and to provide legal certainty. And a society as structurally unequal as the Brazilian one needs to pay special attention to the discriminatory potential of AI systems derived from technical and social bias. So after analyzing, just one moment. So after analyzing all these inputs that we received, as well as examining in depth different topics, the committee decided to adopt a comprehensive approach of the law. This is due to several reasons. For instance, consistency and continuity in the Brazilian tradition on regulating technology. We are used with comprehensive laws such as the Brazilian Civil Rights Framework for the Internet, the Consumer Protection Code, and the Data Protection Act. Limitations of the Data Protection Act, and the idea that the whole life cycle of AI must be covered, not only the decision-making process, but also the creation of models and data training. So I'll start and I'll try to very briefly cover the main structure of the bill. The bill has 5 main axes, principles, the guarantee, just one moment. Principles, the guarantee of a list of rights to people affected by AI systems, the categorization of the level of risks of AI systems, governance measures and obligations, and enforcement structure. So starting with the principles, you can see there are lots of more principles that the bill provides for a lot of principles, but I highlighted just some of them, the main ones, such as non-discrimination, transparency, due process and contestability, human participation in the AI cycle and effective human supervision, accountability and attribution of responsibility to a natural or legal person. And I would like to highlight as well, and that is already the second pillar of the bill, that the bill provides also for rights of the affected person. So there are these rights here: right to receive prior information regarding interactions with AI systems, since the person has to know that it's that he or her is interacting with an AI system. Right to explanation, right to challenge decisions that produce legal effects or significantly impact the interests of the affected party, right to human determination and participation in AI systems, right to non-discrimination, and right to privacy and personal data protection. So I think I can move to our third pillar. I have some time, Luca.
If you wrap up quickly, yes.
Okay, so I'm going to do this. Just one moment. So we have the fourth. Okay, so sorry. There is the pillar regarding the categorization of risks, in which the bill provides for a list. And in this point, I would say that we were inspired by the AI Act, because the bill provides for a list of finalities and of high-risk AI systems. And the fourth pillar is the governance measures. So these measures are mainly addressed to these high-risk systems. These are documentation, use of tools for the automatic registration of the system's operation, performance of tests, data management measures, and adoption of technical measures to enable explainability. The fifth pillar of the bill is about the enforcement structure. In the report, the Commission argues that an administrative structure is needed in Brazil to ensure the rights of the persons concerned in a harmonized way and to provide legal certainty for the enforcement of the law. So, like, maybe I'm just finishing, just one minute. I would say that, just one moment. Now this draft bill was formally submitted to the legislative process, and we expect that it could be intensively debated and improved in an open and democratic procedure. Thank you very much, and I'm looking forward to the debate. Maybe we can discuss a little bit the differences between this bill and the AI Act. Thank you very much, Luca.
Excellent. Thank you very much, Laura, for the very comprehensive, although in very short time frame presentation. And in the interest of time, knowing that we have started with a little bit of delay, I would suggest to move directly to the second country, to Russia, to understand which kind of developments are happening in Russia that has adopted a national strategy on AI recently. And we all know as a very special implementation also of data protection. So please, Ekaterina, you are here with us today to enlighten us on how the most recent development in Russia have targeted AI development and data protection enforcement. The floor is yours.
Thank you. Thank you, Professor Luca, for introduction, and it's a pleasure for me to speak today, to be a part of this panel. I will try to give a very brief overview of the recent development of AI governance in Russia and how it interacts with data protection regulation. So to give you the picture of legal basis for the AI governance, I have put the key documents on this slide. So the vector for the further development of AI governance is predetermined by these particular documents. The key one is the second document mentioned here is the decree, the president from 2019 on the development of AI in the Russian Federation, and it implements the national strategy, a very declarative, but at the same time quite a comprehensive document with the view of further development in this field, and I will further refer to it as the national strategy. And also we have the federal law, which introduced a regulatory sandbox in one particular region in Moscow for the period from 2025. So what should I highlight here is that we still do not have one comprehensive AI law in Russia. So we rather have pieces of regulation in different legislative acts. For example, the data protection law was amended, the law on information and information technologies and protection of information, the law on banks and banking, etc. So now the framework looks a bit like a spaghetti ball when we have different ties between different pieces of legislation, but still this is the task for the Russian legislative authorities to develop one more comprehensive law. Still, according to Stanford AI Index report for the last year, 2022, Russia is the second jurisdiction after the US in terms of the number of acts regulating AI to less or more extent and detail. So what is AI in the national strategy? This is the precise definition from the strategy. It is understood as a complex of technological solutions which include both the hardware and software and also services for data processing. And you can see that the authors of the national strategy have employed the approach of comparing the artificial intelligence with the human cognitive function. although it was not the only possible way which was discussed within the development of the national strategy. We had a more like a technological focused approach, which determined AI in terms of these technological features. But finally, they chose like this more human-based approach, which compares the results of human creative work to that which was created by AI. So the strategy and other documents provide for some principles of regulating for the development of further AI-related legislature. And the key principle is technological sovereignty, which is discussed in different aspects in Russia now, and in the aspect of AI also, which stipulates that a necessary level of independence from foreign technologies should be ensured, and the predominant use of domestic AI technologies. And also, it is not only the technological aspect, but for example, also the educational aspect. We see that there are a lot of educational programs in higher education are now established to prepare the specialists in this field and like to be more less dependent on foreign technologies and human capital. Integrity of the innovation cycle is understood as the interaction of the scientific and scholarly findings with the real sector of the economy, which is, of course, very important too. The risk-based approach to the regulatory impact and human-oriented approach, which I have already highlighted, and it is also seen in the bit restrictive regulation approach, which means that when we see that AI can potentially harm the participants, the humans, not only, of course, in the physical sense, but for example, we have the discussion on how the development of AI can influence the employment situation and what could be the guarantees for those employees who are at higher risk because of their professions, maybe more like at risk due to the development of the AI. And last but not least is the support for competition, which I think speaks for itself. Of course, the state wants to see a number of market players, number of participants in this field, and preclude the situation when the competition is at risk. Still, we have some issues for further consideration, some challenges. And the number one is the data protection issue. The national strategy contemplates that by 2030, there would be the volume of data sets gathered, processed, and published, which would be sufficient to reach the goals set by the strategy. And we have different sectors highlighted in the strategy, for example, the healthcare sector, the public services, the self-driving vehicles, etc. And all they require data sets to be processed, and the strategy contemplates that they will be enough and numerous the types of data, including speech, medical, video surveillance data, etc. And here we have some problems and some discrepancy between the data protection legislature and this AI framework in terms of data localization requirements, and also, for example, amendments made into the data protection law last year in July 2022, when they introduced the amendment, which allows the data operators to transfer data to third parties based not only on a precise written consent of the data subject as it was previously, but on other grounds too. For example, if you have an agreement with a bank to open a bank account, previously for that bank to transfer your personal data to some third-party operators, the bank needed your special written consent. But now they can do it based only on your general agreement with the bank on maintenance of your bank account. But at the same time, the bank has more rights of control on how this third party complies with the data protection regulation. This is an example of some possible way of solutions, but we still have some gaps, like we do not have a precise procedure for depersonalization of data, and this is to be like this gap to be closed by the legislative authorities. The second issue, which is, I think, common for the discussion in all jurisdictions, is the IP rights in respect of the objects created by using AI. The Russian civil code understands the author of IP rights only as a human. So if we think of providing IP rights in respect of the objects created using AI, we need to reconsider the concept of the author and authorship. And last, but of course not least, and here we cannot ignore the elephant in the room, is the impact of sanctions, the sanctions pressure, which of course influences developments in the technologies, including AI. And here we come back to the problem of technological sovereignty, which is very much discussed now, not only by politicians, but of course by scientists and particularly economists, which not only think of whether technological sovereignty as a goal is achievable as such, but also what would be the price, the economic price for such independency in technological fields. So this is the problems to be solved. And of course, we are looking forward to seeing one comprehensive AI piece of regulation. Thank you for your attention.
Thank you very much, Katya, for your presentation. Along your presentation, you mentioned that there are several efforts aimed at experimenting new regulatory approaches, and this is also held at the local level. So there is this case, for instance, of the Moscow municipality experimenting with regulatory sandboxes to foster new type of AI uses. And this, to some extent, has excited some observers willing to experiment AI technology, and also scared some others, aware that this kind of technology may be misused. So could you tell us a little bit more about this experimentation of AI sandboxes?
Yeah, indeed, we have this federal law which introduces a regulatory sandbox, particularly in Moscow, for the period till 2025. And if this experiment will be successful, it may be either extended in time or broadened to other regions. So the local authorities, the regional authorities in Moscow is one of the subjects of the federation, so one of the regions, they have additional rights to implement or to ease regulation, particularly in Moscow, so that these experiments could be carried out in terms of using some AI technologies. To give you a precise example, you might know about Yandex, the main IT company in Russia, and they have one of the experiments is the self-driving vehicles. And if you come to Moscow, to the area where the headquarters of Yandex is situated, you could one day see a self-driving car in the streets nearby. And particularly the Moscow authorities introduced some easement of regulation, both in terms of road traffic regulation for that particular area of the city, to make it possible for self-driving vehicle to ride there, and also in terms of video surveillance from the cameras there, so that Yandex could get access to those data and make this experiment progress. So this is an example of how it works in this sandbox.
Very interesting indeed. And you mentioned also that technological sovereignty is a very a principle that often comes back and is mentioned in the Russian strategy. Another country that has made of technological sovereignty a very core pillar of its developmental and data strategy is India, that has already adopted an AI strategy, but has not adopted yet, actually still in the process of developing since several years with multiple iterations, its data protection bill, also recommendations on non-personal data, which are key to develop AI. So there are a lot of developments very interesting at the Indian level, both in terms of general AI related policies and data protection policies. Please, Smriti, the floor is yours to know more about this.
Thank you. Thanks so much, Luca, and good afternoon to all my co-panelists and all the participants. Just give me a moment. I'm going to share my screen. Okay, hopefully you can all see that. So yeah, as Luca said, there's been some interesting developments in India, and but if you look at it in terms of a legislative framework, it is a country that is, behind the curve in terms of adoption of law or implementation of a lot of what has been thought of at the strategy level in terms of tangible, enforceable action. So that's what I'll just try to give an overview of in the next few minutes. Although we do have an AI strategy, I think the big takeaway from this slide, and I'll go into some of the nitty-gritties, but the main takeaway is that the current focus in India is mainly around promotion, it's around commercialization, it's around innovation. It is not focused around regulation. So although we do have AI principles that have been laid out, which do recognize, as the other speakers have talked about, the general principles around safety, security, transparency, etc., there isn't a move as of now to try to translate this into any kind of binding obligations. And let me just explain that in a little more detail. So we have a government think tank called the Niti Aayog, which in 2018 put out a national strategy for AI. This was a really high-level document which identified certain core sectors where deployment was more necessary or more useful, things like agriculture, transport, health, etc. And also, kind of laid down the pathway to come up with a more detailed framework. And that was followed in 2021 with two new sets of documents. One was a set of principles, which laid out, everything. I won't go into those details, but they are the high-level principles as we see in other jurisdictions. And also a little bit of thinking about how do you operationalize these principles. But the interesting thing there was the operationalization is not contingent as per the recommendations on any legal framework or the necessity of a law. So there were ideas like, one, of course, self-regulation, but also the idea of having a collaborative framework where there would be an advisory body which has stakeholders from across the industry, civil society, government, etc., but which plays more of an advisory and oversight kind of role without having binding powers. In addition to this, there have been a number of other committees which have looked into questions of skilling, data availability, etc. But all of this has remained at a recommendatory kind of stage. In terms of legal frameworks, the government has actually recently said in the parliament that we are not looking at an AI law or a comprehensive AI legislation at this point of time. But there is a debate around the creation of a new statute, which is being called the Digital India Act. And one of the pillars in that will be, as per, now again, we have only very high level information on this because although the government is doing consultations around this act, it's not released a very comprehensive document. So we have something the equivalent of a slideshow really, which is laying down the high bullet points of, what is the kind of thinking that's going on behind this act. But having said that, there is one pillar there that they identify about high risk cases of AI. And it talks about the need for transparency that, maybe risk cases like content moderation and the possibility of bias in that. So that's one example that it gives. But really the idea is about algorithmic accountability being introduced only for a very specific subset of high risk cases. But we need to see how that document will evolve once it takes the shape of a bill. In parallel, of course, there are a number of other initiatives. As I said, the idea is around promotion and innovation. So there are a number of initiatives there, a lot of them in collaboration with academia, in collaboration with not so much with civil society, but with the industry, where the government has created something called the National AI Portal, which is a hub of all the information around developments of AI in the country, all the developments that are taking place. There are centers of excellence that have been set up in various academic institutions. There is a supercomputing cloud-based facility called Eravat, which is being tested at this moment, which is again, an idea of promoting innovation through the creation of this common infrastructure. And of course, like the others talked about, there are initiatives about skilling and training and reskilling, and specifically youth-centered initiatives which about promoting AI amongst the younger population. And all of this has, of course, been very closely linked with, discussions around the data ecosystem, because obviously data is one of the big feeders which goes into the development of AI. And there are a couple of strands of discussion going on that. So as Luca talked about earlier, we don't have a data protection bill as of yet. This is a debate that's going on for at least 5 years now. There are drafts which are going around. I don't want to go into details because again, what we have right now is still at a draft stage. It's not something which has been introduced in Parliament or reached more advanced stages, but there is a pretty bare-bone kind of a bill which is on the discussion table right now. But although the law hasn't proceeded, what has proceeded is a technical architecture which is centered around consent management. So it's called the Data Empowerment and Protection Architecture. And the idea of it, an idea of all of these developments is that in the discussions leading up to it, there is a lot of emphasis on AI and how you need both the protection of data, but also the creation of data sets for AI to flourish. So a lot of this is about enabling. So this particular architecture, for instance, is about enabling intersharing of data, interoperability of data in a manner which is with the consent of the individual. Besides this conversation on personal data, there are recommendations and proposals going on in the field of non-personal data. So which is either personal data which has been anonymized and aggregated where you can't identify the individual, or data which was never about individuals in the first place. And there are two strands again. There is this proposal of having a non-personal data regulatory body, which will collect data both from private entities and public entities and make this available for the benefit of the community and for a common use, so to say. And then there is this more public sector centric initiative, which is the idea of creating an India Data Management Office, which will be a hub for all the data, which is a non-personal data emerging from across the public sector, from various organizations in the public sector. And the idea is to standardize this data, to pool it together into one resource so that whenever you want to do evidence-based policy making, there is that one-tap access to that data. And from the proposal as of now, it seems that selectively private entities may also be able to access this data, but it's categorically said it's not meant for the benefit of big tech, but for the benefit of innovators and small startups within India. So yeah, that's the broad overview, and happy to take any questions. Thank you.
Excellent. Again, in the interest of time, I suggest that we keep questions towards the end, and let's move to our fourth country of the day, China, which has been adopting an incredible amount of data-related policies and regulations and laws over the past 2 to 3 years, especially. Literally an enormously intense data policy making happen in China, with not only the adoption of people, the data security law, several regulation of the Cyberspace Administration of China, regulation in AI national strategy adopted and enacted, and of course also the regulation on algorithmic recommendations from ISPs. Very complex scenario. Wang, it's your task to provide us a little bit of clarity to understand these rather intense developments. Please, the floor is yours.
Thank you, Luca. I hope that my clarity framework works well this time. Hopefully, I can address the complexity. Yes, I have some slides to share as well. Okay. So, hello, everybody. Thanks to Luca for the invitation, as always. I'm going to share with you some a big picture of the AI and our algorithmic governance model in China. Basically, all of us may know that there is kind of geographical effect models of AI governance already. For example, as Laura has shared, Brazil has a kind of systematic approach to legislating artificial intelligence, and the EU has this approach as well. And in some other jurisdictions, they adopt data protection as part of artificial AI regulation. And China is a sort of hybrid. I will explain that it currently considering using data protection approach as well as some specific algorithm act or regulations. But what is the real Beijing model of AI governance? Several years ago, I consulted with some scholars from European Union and UK. We concluded by saying that For example, United States adopted a liberal market approach to AI innovation or governance, and the European Union adopted a very, regulatory approach regulating artificial intelligence. And China is sort of, the style is a sort of a state-endorsed approach to, sort of a pro-AI innovation approach. But this was a sort of, this was a story 2, 3, or 4 years ago, and the story changed a little bit now. But it's still good to know the prehistory of AI innovation policies in China. For example, as Dr. Li Kai-fu wrote in his book, China has a large population, and it sort of can be regarded as a Saudi Arabia of data. And at the same time, China adopted a series and a consistent policies on artificial intelligence from even since 2015. I think the rationale is sort of aggregating training data for AI by encouraging the large population to participate in the digital transformation. And this model somehow works. If you compare the AI innovation, outcomes, at least if you look at the paper, academic paper number or something, China is sort of catching up. But there is still a very big problem between the central government and the province, the localized governments at the provincial level, for example. It's a sort of kind of federalism problem. There is some unevenness of the policy distributions in terms of AI innovation, and that's really why. That's why China would like to introduce the East-West computing transfer projects to solve the imbalance of data volumes and the computing power between the East and West of China. But if we look at the private sector, I think have known this very good sentence from the documentary made by Netflix: if you are not playing for the product, then you are the product. And also the winner of 2011 Nobel Prize in Economics, Thomas Sengen, also said AI is actually statistics. And so in this regard, if we look at the interaction between data and algorithms, China is a very, complex system of data protection or data governance from, for example, national security law, cybersecurity law, data security law, civil code, and the PIPL, and the very recent antitrust law amendment. And I have another approach to understanding China's algorithmic governance is that it's sort of has a focused on content security. For example, it introduced the provisions on algorithmic recommendation management and the regulations on deep census management. For example, it would like to regulate deep fakes. And very recently, China introduced the regulations on generative AI. Just precisely, ChatGPT was born in the world. So in a sense, China regarded the data protection, data security, algorithmic governance as a whole. For example, in the PIPL, its Article 57 introduced the gatekeeper obligation for big platforms. It sort of gives the platforms some obligations for algorithms as well, and particularly through Article 24 and Article 55, it regulates automated decision-making as well. And Article 27, it regulates facial recognition, sort of relevant to artificial intelligence as well. At least it relates to biometric data, right? And if we consider the recommendation algorithms, there is a regulation already there, and it's already effective. So, and basically the biggest step of this regulation is was to introduce the algorithm registry system. So basically, who is subject to the registry system? For example, those service providers that provide channels for expression of public opinion, and those service providers that have the ability to mobilize the public to engage in specific activities. I think that's a sort of the Chinese approach to content security. And what need to be registered? For example, it requires those information relating to algorithm, subject information, project, and function information. Basically, the public sector would like to know the functionality of algorithms in this case. And very recently, China introduced the generative AI regulations. It basically covers quite a few, subject, for example, content moderation, algorithmic discrimination, IP protection, fake information, including mis and disinformation, and for sure, data protection. And the core target is to make sure that generative AI services adheres to the legal and ethical principle and aligns with the core socialist values. Yes, so in this case, probably we can discuss this later to save time. I think my time is running out already. And another approach to AI governance in China that it uses IPs as a sort of very big milestone. For example, there is an algorithmic copyright case about platform liability and algorithmic aggregation of content. And another approach is IP and antitrust, for example, through the anti-monopoly guidelines in the field of public platform economy to tackle the specific problem of big data, 杀熟, it's a sort of kind of price discrimination. Okay, I hope this is the end of my presentation. I look forward to questions. Thank you.
Fantastic. Just a very brief follow-up question, because I'm intrigued. And when you rightly mentioned that as soon as ChatGPT became a sensation, China introduced a draft regulation to regulate generative AI. So how would China regulate the development of large language models like the ones that power ChatGPT or other generative AI chatbots?
Yeah, I think that's a good and timely question. Thank you for the question. Actually, ChatGPT is forbidden in China. We have no access to the ChatGPT, but because as you know that China is a lot of the indigenous projects. There is a Google-like service named Baidu, and it already introduced the Baidu. When using sort of like ChatGPT thing. So that's the reason why China still has the interest in regulating generative artificial intelligence. I think in the near future, there will be three, areas that will be deeply regulated. The first is sort of like the data protection for sure. As we all may know, there is a substantial interaction between training data and generated content by AI. And the second area is the legality requirements of training data. Basically, it's about the copyright. For example, European Union, as I know, they just introduced some novel requirements on the training data. The copyrightability of training data. For those generated AI services use, copyleft data to train their artificial intelligence in this case. So IP issue will be another probably area. And the third one I've mentioned in the slide, probably it's so-called the content security. And this basically introduces quite a series of obligations. For example, you have to, and this application is very technical. So I think China's, the Chinese authority introduced quite a few technology experts to the policy-making process in this regard. For example, there is some reporting obligations about the labeling process. Training data and the labeling. The labeling process, it's very technological. Complicated, complex. But China, I'm confident that it introduced quite a few technology experts to the policy-making team.
Okay, excellent. Now, last but of course not least, South Africa, that has been also developing a draft AI law and policy. It has been busy implementing COPIA, the National General Data Protection Law. Sizwe, Snail, please, the floor is yours.
Thank you, Luca. I'm here to talk about data protection from an African perspective, a South African perspective. The development on AI legislation, I must say, has been relatively slow in South Africa in comparison to what I've heard here earlier on today. I'll just generally talk about artificial intelligence, how our law has dealt with it currently, be it from the Constitution or the law itself. And some African initiatives, I don't think further discussion will allow in terms of time. So what's very, very important from a South African perspective is to, we don't have a draft law. There are whispers of a draft law, but, when you're talking about a draft law, the first point of contact is the Constitution in our country, as it is in most countries in the world. So there are these principles, constitutional principles, that are internationally accepted principles, transparency, accountability, privacy, non-discrimination, fairness, reasonableness, freedom of expression, autonomy, dignity. I mean, these are all internationally accepted human rights principles which we have in our Constitution, which I believe would be the cornerstone of drafting any AI legislation. As mentioned to you, we don't have a specific AI legislation, and in 2019, our president felt, in line with the Presidential Commission on Fourth Industrial Revolution, that artificial intelligence come out as one of the key important aspects. We have seen now one or two artificial intelligence institutes at the Attoneys University of Technology, the University of Johannesburg, and I can surely assure you there will definitely be more academic initiatives. But in terms of the legislative approach, I think we have been a bit lagging behind. Not necessarily to say that our law has never accommodated AI. For instance, the old Electronic Communications Transaction Act, Section 20, spoke about the automated agent and the consequences that happen as a result of doing a transaction with an automated agent. We also have in our POPIA, our data protection law, a provision that prohibits decision-making upon automated process based on personal information may have of a data subject. So with that having been said, this whole provision about automated agents is quite, should I say, contentious, because right now in South Africa you have a whole lot of automated agents. You have chatbots, you have all sorts of points of entries to electronic transactions that use electronic agents. As a result, our Financial Services Conduct Authority also came up with the rules as to how an automated agent should behave. That's quite interesting. And also Section 4, we criminalize the use of or acquisition or access or deception of electronic data by electronic means or other means. This would, I think, include the means of artificial intelligence. Quite interesting to mention that the Malabo Convention, and I think I've mentioned twice or thrice already, has now finally got traction. And in the Malabo Convention, we also have whispers. I don't want to sound negatively, but we have whispers of AI pertaining to automated processing of personal information, as well as a similar provision on automated decision making. So we find that in Malabo. What is very, very refreshing also are the principles related to data protection. And this came out very clear during the COVID period when Africa noticed that, look, we need to do something. 2021, we also have this resolution on the need to study human rights as well as artificial intelligence, robotics, and emerging technologies. This is now the position where Africa as a continent has taken a position to start drafting laws, having ethics that govern AI, as well as, regulating safety and security when it comes to AI processes. Also, AI is seen as a driver of business opportunities, and in doing so, obviously, some of the ills that come from AI, be it biases or discrimination, those must also be considered when drafting AI legislation. So in short, to keep in line with the 7 minutes given, I think South Africa must give effect to the Fourth Industrial Revolution report. The drafting of an AI law is no longer a like-have, it's a must-have, it's an urgent thing to do. This must be in line with international human rights, which I think I've expressed to you now in line of our constitution. And I think that will be the time that's allocated for me. There will be a development of these issues and further action.
Thank you very much for this, Sizwe. There are a couple of very interesting points that I think you raised. The first one that I'm not sure all the other participants and people that are listening to us from home already are aware of is that the 15th country that was needed to make enforceable the Malabo Convention, the African Union Convention on Cybersecurity and Data Protection, was finally achieved. So this 15th signatory a couple of weeks ago. So now the Malabo Convention will be the second treaty, together with the Convention 108 of the Council of Europe, to be an international binding document on data protection, which is very interesting development. And the second one that I think is very interesting is all this whispering about data protection, AI law and AI norms, both at the larger African Union level, but especially at the South African level. So can you tell us a little bit more, also thanks to your insight of South African politics, what kind of concrete steps is South Africa taking to draft an AI law?
I think from a technological perspective and from an academic perspective, I think South Africa has taken now the necessary initiatives to start focusing on AI. Let me repeat that. I think we've taken the academic as well as technical priorities, focus on AI as a priority. We'll see in higher education institutions, AI now is a compulsory subject, 1 or 2 of the universities, especially those teaching, should I say, technologically related subjects. So from that perspective, I think we are moving in the right direction. from a legislative point of view, I think we are lagging behind. I think we are focusing on urgent matters that South Africa as a country has to deal with. But I can assure you, in the next year or two, knowing South Africa, we will come up with a draft piece of legislation in terms of the Fourth Industrial Revolution report, and this legislation, similar to that of Brazil, will have, the human rights as a priority.
Okay, excellent. I think that now we can get into our question and answer segment. We have two questions. One for Laura on the comparison between the AI regulatory framework proposed by Brazil and the EU proposed AI Act. The AI Act was a considerable source of inspiration for the Brazilian Congress and for the committee that Laura chaired as a rapporteur. So which kind of similarities can we find between the AI framework proposed by the European Union and the one proposed by Brazil?
Thank you very much, Luca. I would say that the main similarity is this comprehensive approach, the idea that you have to address the whole cycle of AI. But I would like to highlight as well maybe the main difference, and I would say that is this: we combined a risk-based approach with a right-based approach. So I think that's maybe the main difference. Since the bill provided for many rights for the affected person. And in this sense, we believe that on the one hand, it's important to have the enforcement by an administrative authority, but on the other hand, you still have to count with the judiciary to implement rights and to implement obligations. So I think that's the main difference. And another difference that is related to this one is that in Brazil, when you are implementing rights, you can do it also through civil society, also through NGOs. So this is also provided by this bill. And I think that's a huge difference when we compare with the AI Act.
Yes, indeed. And indeed, it is very challenging for individuals not only to understand the impact that AI system may have on them, but then also to be able to prove that there is any connection between any potential damage they suffered and the misfunction or the intentional bias programming of AI systems. Another question to go on with our question and answer segment for Smriti about the impact that the recent Indian policy making about international data transfers can have with regard to international data transfers between India and other countries. So what the recent Indian posture regarding international data transfer, what would be its impact with regard to its connection and free flow of data with other countries?
Yeah. Thanks for that question, Luca. So yeah, India has this interesting, situation that it finds itself in, because on one hand, it's been a great beneficiary of the digital revolution, a lot of which has happened because of free flow of data. And on the other, over the last few years, a lot of sectors have seen a more restrictive stance where, in sectors such as payments, in telecommunications data, government data, we are seeing a position where there are restrictions on free flow. There are soft or hard localization requirements. And this really hit the peak with the discussions around the personal data bill, where previous versions of the bill, not the current one, but previous version had fairly strict localization norms, and that really opened a debate whether India can really integrate and become as much of a player in the world economy, digital economy as it wants to, while having restrictive positions. And that kind of force seems to have led to a dilution of the position, and the current position is about whitelisting of countries where the government will specify where the data can flow. So it's not still unrestricted free flow, but it's definitely an improvement than the localization provisions earlier. And that's also interesting in terms of, India's positioning globally, because, unlike all its G20 peers who have agreed to this principle of data free flow with trust, and they're trying to move towards principles and implementation of that, India has, been reluctant and has refused to be part of that, what is called the Osaka track of discussions on data free flow. But India also wants to promote digital public infrastructure and interoperability of digital infrastructure globally. And that, of course, will require data flows if digital payments is to take place cross-border, or, consent management has to take place cross-border. That will require some kind of data flow. So I guess this balance will somehow be achieved with India's interest of digital public infrastructure and the other countries insisting on, cross-border flows. I think because of these two interests meeting, there will be some kind of balance that will be met.
Fantastic. And just to conclude, as we still have 5 to 6 minutes, a final question for everyone to have your considerations, and maybe you could be able to have a little bit of comparison between the BRICS countries. So to what extent are private or public actors that are deploying AI systems in each specific country considering data protection norms with regard to automated processing of data? We have in almost all countries, with the exception of India, we have regulators that are already implementing law. And so to what extent are the actors that may process personal data to take automatic decision de facto respecting the law? Is it possible actually to understand and to have a real answer to this question? So is it possible really to understand which kind of compliance level exists with regard to automated processing of personal data in each specific country? Who wants to start? Yes, please, Sizwe.
Right. Considering, in South Africa, like I said, we have a body of law that accommodates AI to some extent. But I think what the problem is that I think people still think AI is an abstract matter. People are not aware how much we use AI in our day-to-day life. So I think AI as a legal concept, as a concept that people must become aware of, that it is part and parcel of our lives, I think is something where, I guess, I don't want to use an overused word, but capacity needs to be on that, and awareness, very much important. I think once you have people, in the right mindset at AI, you can start talking about legislative AI. In the data protection, there is this provision about united decisions. I don't think there exists a study that has comprehensively looked at this. So I don't want to speak without relevant statistics, but I think the provision related to automated decision-making is going to be one of the complicated things that our regulator has to deal with, and we look forward to hearing some of the decisions.
Excellent. Do we have any other quick and sharp replies before we conclude our panel? Smriti, do you want to? Oh, sorry, Laura, please go ahead.
Okay, so I think, as you know, Luca, we are developing this culture in Brazil. I would say in the private sector and in the public sector as well. So I think that it's an ongoing process. But I must say that I think that our norm regarding automated decision making is a little too, it's not so wide, or it's not so protective. So maybe that's why I think the Artificial Intelligence Act is so important. But I do think, I do agree with you that we have to start to comply with the data protection norms that already exist. So I think that's a very important point.
Yeah, and also staying in Brazil, perhaps the fact that I myself, I petitioned the ANPD to have them evaluating where ChatGPT is in compliance or not with automated processing of personal data might be a very good occasion to know, first, how long it will take to reply, and second, have more clarity on this issue. Smriti, please go ahead.
Yeah, I just wanted to add quickly that, obviously in the absence of a data protection bill or an AI law, there isn't really any kind of known compliance that is taking place. So there is rampant adoption both in the public and private sector. But an example, interestingly, is on, some issues. Recently, for instance, there was this report put out by the think tank Niti Aayog on a particular deployment of facial recognition in the context of boarding at airports. And facial recognition is something which has seen a lot of pushback, as you can imagine, from civil society. So sometimes, even though we don't have a legal framework, pushback and questioning from the civil society does lead to some kind of internal reflection within the government. And that's a rare example, which doesn't happen often, but that's one interesting kind of document that has come out as a result of that pushback from civil society.
And indeed, yes, even when there is no regulator, the fact that there are social watchdogs that can maintain a little bit of pressure to control the deployment of this kind of system is indeed very healthy. Do we have any final remarks before we close? Katya or Wei, do you want to conclude with a final statement or remark? Wei, please go ahead.
Yes, I think as regards your question, I think because in the Chinese PIPO we have Article 24. Yes, basically, to deal with the interaction between data protection and automated decision making. Basically, we require sort of like, for example, the opt-out option. For example, those social media apps or the mobile apps have to offer the opt-out option for automated decision making. That means if the users don't like the automated decision or use their personal data for recommendations or something, they can just click on the button, and then there's no kind of precise recommendation for them. And the other is the use the data protection impact assessment, the approach to tackling this automation decision making. For those platforms use of data to do automated decision making, there must some influential effect, and the data protection impact assessment should be a approach, at least according to the law. Yes.
Okay, excellent. Katya, do you want to have the final word to conclude our panel?
Just one minute remark. As I mentioned, last year we had some amendments to the data protection law, and if before that it was almost impossible to fully process cloud data, including for the purposes of AI modeling, because it required always a precise written consent from the subjects. And the prerequisite for these amendments was a particular case when it was needed to use some external supercomputer to process such data, and then it gave a push to the legislative amendments. And we will still have to see, because the law is recently new, it's in effect for less than a year, how the operators comply with this increased control over the third parties to whom they can transfer the data. So whether they fully comply with these increased obligations to the individuals, and so we will see, I guess, that quite in the nearest future how these amendments really work.
Excellent. Thank you very much to all. Let me also share that most of the research that we might have mentioned about data protection and AI laws in the BRICS countries may also be found in open access on the cyberbrics.info website. And we are also preparing a piece of research dedicated to AI and data protection regulations in the BRICS country that hopefully we will present in August in South Africa at a convening organized by our friend Sizwe Snail right before the BRICS summit at the end of August in South Africa. Thank you very much to everyone for the participation. It has been indeed a very productive and fun discussion. I wish you everyone an excellent afternoon or evening, depending where you are looking us from, and see you to the next CyberBRICS panel at CPDP. Bye bye.